Welcome to what I believe is the first Singapore Symposium legal theory seminar of this academic year. And what better way to kick it off than to have this wonderful paper by Professor Heidi Hurd. Heidi M. Hurd is the Ross and Helen Workman Chair in Law and Professor of Philosophy at the University of Illinois and the co-director of the Illinois Program in Law and Philosophy. She has published dozens of articles in leading journals on legal topics that are fruitfully informed by philosophical analysis, and she is the author of Moral Combat, Moral Puzzles, and Legal Perplexities, and The Virtue of Bankruptcy, forthcoming from OUP. As I said, I'm absolutely delighted. She is presenting us today, so over to you, Professor Hurd.
Thank you. Well, thank you for coming to this session. It's a real thrill to be here. The paper that I am inviting you to help me with today is going to be part of a forthcoming book on the nature and value of liberty that my husband Michael Moore and I are collaborating on. It's a paper that takes up the classic question of why lawmakers might be morally obligated to leave citizens at liberty to do what lawmakers themselves consider morally impermissible. Now, almost everyone rejects autocratic versions of what political theorists call perfectionism, namely the thesis that whenever possible, the state ought to use the long arm of the law to achieve moral perfection of its citizens by coercing their fulfillment of their moral duties and their cultivation of their moral virtues. I mean, in the famous language of liberalism, most of us think that the state ought to leave us at liberty to pursue our own conceptions of the good, that it ought to preserve our freedom to make significant life choices, that it ought to refrain from substituting its judgment for ours, even when our judgment is likely to lead us astray, right? So most of us think that government ought to leave us free to smoke and overeat and take drugs and gossip and waste our time and waste our talents and, consume pornography and break promises to friends and join racist chat groups online and fritter away our time and lie to family members and cheat on our spouses and indoctrinate our children and, refuse to give others possessions that they would value far more than do we. Yeah? But the question is this: how do we morally justify the demand that law accord us rights to say and do things that are arguably and even blatantly wrong? What resources does morality itself have to make sense of the claim that law morally ought to observe limits to the enforcement of morality? Yeah, that it ought to permit citizens broad discretion in authoring their lives, even when they abuse that discretion, that it ought to tolerate the intolerant and permit the impermissible. And this is really the question for our book as a whole. This chapter is preparatory to solving that puzzle, because this is an exercise in what I call moral cartography or moral map making. Its task is taxonomical. It lays out what I hope is an exhaustive list of the morally plausible answers that can be given to this classic question in political philosophy. So the paper does not itself construct a positive theory of political liberty. That's the project for our larger book. This paper rather identifies and initially appraises the potency of the ingredients that might be included in a comprehensive recipe for political liberty. Now, the core of the project is a crucial assumption, one that it's important for me to make explicit from the start, but one that I'm not going to defend here. It's the assumption that law cannot part company with morality in the sense that it cannot regulate conduct that is not in some sense immoral. And to reject this assumption is to reject the coherence of my project. Because if law is either properly or inevitably impervious to the morality of the actions that it regulates, then it's surely confused to seek a theory of liberty within contemporary moral theory. Put differently, one shouldn't care how moral theorists might morally justify legal rights to do moral wrongs if legal rights need not be morally justified. Yeah? So now let me make clear. I'm using the term morality here very generously. That is as synonymous with the extension of practical reason. I take all reasons that are relevant to state actions to be moral reasons. That is, reasons of a normative sort that can be shown to follow from or be at home within the principles of one or another traditionally recognized moral theory. And it's by virtue of conceiving of morality as coextensive with practical reason that the question of political liberty is so interesting. Because, of course, then the question really is, how can practical reason justify state officials in refraining from enforcing the conclusions that citizens seemingly ought to reach via their exercise of practical reason? Okay, what you have in front of you, I hope, if you got the handout you should have, is the table of contents for the paper, and it's just going to double as your outline of my talk today. And you'll see from it that the paper is organized into 5 parts. And I'm going to walk you through some of these in some detail, and I'm going to deal hastily or not at all with others. But hopefully you'll always be able to keep track of where I am by just consulting this sort of overview of the project. Okay, so here we go. Part 1 starts with a non-starter, namely the attempt to extract liberty from moral relativism. So it's an infamous freshman mistake to argue that all moral truth is relative to people's beliefs about it, and hence that all people's conceptions of the good are deserving of equal tolerance, right? And not only is metaethical relativism probably false, but the principle of tolerance clearly does not follow from it. Because if each person's beliefs are equally true, then it must be moral for the person who thinks that tolerance is immoral to be intolerant of the actions of those with whom she disagrees. So metaethical relativism in all its forms lacks the resources by which to generate a principle of tolerance that makes it right for otherwise intolerant legislators to respect the choices of citizens with which they disagree. Okay, in part 2, what I do is I take up arguments that are all similarly designed to demonstrate that certain actions defy moral categorization by the state. But none of these arguments rely on moral skepticism. The arguments that I address in section A of this part exploit the hypothesis that morality itself is gappy. On a gappy view of morality, there are instances in which morality simply does not speak, or it does not speak definitively. And if law cannot justify regulating conduct that is not in some sense immoral, then it cannot extend its authority to actions that fall within the gaps of morality. Now, what I do in the paper is take up 7 arguments that are designed to demonstrate that in one manner or another, morality plausibly possesses gaps that provide people with opportunities for morally unconstrained choices. So the first is the view that in some circumstances, morality is just silent. It embodies vacuums within which conduct is amoral. These vacuums are arenas of moral freedom because within them one is without morally relevant reasons for action. One is unconstrained by practical reason. One is free of moral concerns. You might think of these vacuums or these pockets as sort of little mini moral states of nature. Political liberty would naturally derive from moral silences of this sort because in the face of such silences, state actors could have no reason to complain about citizens' freedom of choice. Now, there are several problems, though, with premising political liberty on the notion of moral silence. One is that these sorts of moral vacuums have to be really puzzling to consequentialists and to deontologists who defer to consequential reasoning or decision-making whenever so doing does not lead to rights violations. Because for all of these moral theorists, all choices, at least those that are not subject to deontological constraints, all choices are properly judged by their consequences. And inasmuch as all choices have consequences, morality is never silent for these theorists. People never enjoy circumstances in which reasons of normative importance do not bear on the choices, and so practical reason is never without work. Okay, so the second possible source of gaps within morality derives from moral conflicts. So some might think that freedom comes not just when morality says too little, i.e. when it's silent, but also when it says too much. That is, freedom comes in circumstances in which morality issues multiple obligations that are conflicting. Now, it's surely logically impossible for morality to contain truly contradictory maxims, do A and do not do A. But it's logically possible for morality to contain simultaneously binding obligations, do A and do B, that as a practical matter cannot be mutually fulfilled. You can think of Sartre's famous dilemma of the son who's simultaneously obligated to stay at home and care for his sick mother and also to join up with the Free French to fight against Nazism. Yeah? If moral obligations like these can be in genuine, irreconcilable conflict, then it would seem that people must be morally free to choose between them, because no choice can be better or worse than its equally demanding alternative. And it would then seem that the law would lack any justification for substituting its choice for that of the individual who is gripped by such a dilemma. Now, of course, how plentiful a supply of political liberty can be harvested from this source depends on how many moral conflicts people in fact confront, right? And more importantly, it turns on one's philosophical appetite for moral conflict to begin with. I mean, many deontologists believe that moral conflict is an illusion, that there are principled means of resolving apparent conflicts. So some argue, for example, that obligations have different weights, so that in a case of apparent conflict, like Sartre's example of the son, one does the right thing if one fulfills the weightiest obligation. Others argue that rather than outweighing one another, obligations interlock, so that in any case of apparent conflict, one has to determine which obligation makes an exception for the other. If either of these views of morality are more plausible than one that contemplates double binds, then any attempt to locate political liberty within moral gaps will have to look for other sources of moral gaps, right? Because on these accounts, apparent conflicts are not real conflicts, and they thus don't provide opportunities within which to make choices with moral impunity. Okay, so third on the list. The analog to moral conflicts for consequentialists are moral ties. If there are circumstances in which two or more actions yield the same net balance of good and bad consequences, then a consequentialist morality will be silent as to the choice among such actions. Ties constitute gaps in a consequentialist moral system, moments in which morality itself affords people the ability to make choices, no one of which is better or worse than the other. Now, like all the other arguments about moral gaps, this argument locates liberty, political liberty, in an absence of justification for state action. Choices among equally good actions are equally good, and thus they can provide no justified basis for state interference. Now, the fourth means of denying that all moral questions have determinate right answers that could be imposed by law is provided by those who believe that there's a plurality of incommensurable goods. So Robbie George has claimed, this is a quote, "Human life, health, friendship, knowledge, skillful work, and play are incommensurable because they provide ultimate reasons for choice and actions. These goods cannot be weighted and measured in accordance with an objective standard of comparison." So by postulating a plurality of basic goods that simply cannot be compared to one another, incommensurability theorists deny that one inherently good action can be better than another. Choices between incommensurable actions, then, are like choices between actions that have tied sets of consequences, because no determinate answer follows from applying a maximizing principle, right? Now, once again, political liberty falls out of the state's inability to judge its citizens' choices between incommensurable goods to be wrong. Now, the price of this argument is the apparent implication that any choice between basic goods is necessarily arbitrary. So as George Wright complains, incommensurability theorists can provide no argument for interrupting one's recreational coffee drinking in order to rescue one's friend from a painful accidental death. Well, I ultimately think that George Wright is correct in drawing out this implication, the upshot of which is that incommensurable pluralism is highly unintuitive and is therefore an unduly expensive way to purchase a theory of political liberty. Okay, the fifth source of moral gaps that might derive from a particular view of threshold deontology. So on any view of threshold deontology, people are generally bound by categorical obligations that prevent them from violating others' rights in the name of good consequences. Yeah? I don't get to, kill James to save Andrew and Michael. But when no. but when the consequences of adhering to those obligations become very grave, when everyone in Singapore will be instantly obliterated if a terrorist isn't tortured for life-saving information, then people are released from those otherwise categorical obligations. That's the claim of any threshold deontologist. But now, on one view of threshold deontology, once one crosses the threshold beyond which deontological obligations do not apply, one is altogether without moral constraints. One is beyond morality. One is in a moral state of nature. All is fair in love and war. Yeah? Now, as an account of when people ought to be left alone by the state, this view invites the same problems as did the argument for moral silences, except its ironies are perhaps greater. Yeah, because on this view, when the moral going gets really tough, morality runs out on you, right? When we need the lessons of morality the most, morality speaks to us the least. When moral tragedies threaten to become moral travesties, morality ceases to constrain us. So in short, morality concerns the relatively trivial, but not the really important. Now, those who believe that this gets morality exactly backwards then need to reconsider the moral implications of positing thresholds within a deontological morality that are thought to release people altogether from the grip of morality. And of course, there are other theories of threshold deontology that don't do this. Okay. So on the sixth source of moral gaps, that's provided by a robust theory of what you might think of as moral individualism. So moral individualists are attracted to a gappy view of morality because they think that in many circumstances, the only reasons that apply to people are those that are born of their own personal projects and interests and circumstances and talents. So this theory trades on one means of distinguishing agent relative from agent neutral reasons for action. So in this context, agent neutral reasons for action are reasons relevant to all people's choices, to yours and to mine. So for example, it's of agent neutral moral relevance that someone's going to cause another pain or reap ill-gotten gains or con someone out of their hard-earned money. The fact that an action threatens one of these results is a reason for the agent not to perform the action, but it's also a reason for you and me to seek to prevent that action. In contrast, agent relative reasons for action are reasons that apply only to the agent from whose chosen projects they derive. So, for example, it's of agent relative moral significance that an action of mine will thwart my personal career goals or do damage to a valued friendship of mine or require the sacrifice of one of my private hobbies. It might require me to sacrifice going whitewater rafting. Yeah? The fact that an action risks harm to my own personal projects will be a reason for me not to perform the action. But it's not going to be a reason for you to prevent that action, because by virtue of its agent relative status, it's not a reason that affects the morality of your conduct, doesn't enter into your practical reasoning. So, between the gaps of agent neutral morality, moral individualists, as you might think of them, believe that actors are at moral liberty to pursue their own conceptions of the good, because their own conceptions of the good are the only sources of reasons for action within those gaps. Now, agent relative reasons for action appear to provide a pretty fertile source of liberty, only if we're prepared to grant that decisions that seemingly concern only oneself and one's own projects are really morally irrelevant to others. And here's just one reason among several to think that this might not be so. So if choices that only implicate one's own projects and goals are immune from others' judgment or interference, then this suggests that there can be no justified instances of paternalism, at least vis-a-vis reasonable, rational adults. That is, if paternalistic interventions are motivated solely by the interest in protecting others from self-destructive choices, rather than by an interest in preventing them from causing third-party harms, then it would seem that such interventions must always be unjustified. Because on this view, no one can have a moral interest in another's self-destruction, right? No one can find another's personal projects and passions wanting or unworthy. But it does seem that there are instances in which others, including state officials, are justified in rescuing people from themselves, including people who are as rational and capable of self-control as any ordinary adult, as rational and capable of self-control as all of you. So, for example, when people are subject to social rules backed by powerful peer pressures that demand self-destructive choices, take the tradition of dueling back in the 18th and 19th centuries that people would subject themselves to because the peer pressure was so enormous. Or think of the contemporary cowboy taboo against wearing helmets in rodeos. I don't know if you guys have rodeos in Singapore. No? No rodeo in Singapore? Well, I come from Wyoming, and Wyoming is cowboy country. And if you ever see a cowboy wearing a helmet when he's riding either a bucking bronco or a bull, oh, that would be so humiliating for that cowboy. But you know what? It's only humiliating because they've got this weird taboo and nobody feels like they can break it. It's the stupidest thing in the world to get on a bucking bronco without a helmet, right? So the law might plausibly step in, as it did to regulate dueling, right? The law might plausibly step in to regulate choices like these as a way of rescuing people from their own perfectly rational and voluntary submission to coercive social rules that are self-injuring. Or think about when people find that particular passions just consistently overwhelm reason in self-destructive ways. You know, for example, by motivating them to continue to smoke in the face of research that makes it perfectly clear that it's a deadly thing to do. The law might plausibly be employed paternalistically to redress their volitional impairments by simply foreclosing the possibility of indulging those temptations. Or when the consequences of actions are both grave and irreversible, as is true for slavery pacts or organ sales or self-mutilation, it would seem morally plausible for the state to create obstacles to prevent hasty choices. Now, if any or all of these examples tempt you, then you might think that state paternalism is not always unjustified. And then it's going to be really important to be cautious about asserting that choices that are primarily harmful only to the realization of someone's personal goals and projects don't give others reasons for intervention. Okay. Deontologists now might claim that the seventh and final source of gaps within morality consists of those categorical duties that are imperfect, duties that by their very nature permit exercises of choice that cannot be impugned and thus cannot be justifiably coerced. Now, there are two different accounts of imperfect duties, one from John Stuart Mill, one from Immanuel Kant, and because you already know what I think about Kant, I'm going to focus on Mill's understanding to give you a feel of how imperfect duties might require legal liberty. So on Mill's understanding, imperfect duties permit choice about when and how to satisfy them. I mean, think about it. We're each obligated to be charitable, but not towards any one person on any one occasion, right? We can choose to whom and when our philanthropy is directed. Now, if people have imperfect duties of this sort, then there seem to be good reasons to think that the law cannot coerce their fulfillment, right? Because first, inasmuch as an imperfect duty does not compel any given action, the state can't claim that on any given occasion, a particular act or omission is a violation of that duty. And second, if, for example, the state tried to guarantee that everyone fulfilled, say, their imperfect obligation of charity by, for example, mandating that people give a certain percentage of their income each year to recognize charities, the state would likely run afoul of either the principle of weak retributivism or the requirements of the rule of law. Now, why do I say this? Well, imagine a person who violated that law and kept all of her earned income for personal use. But imagine that she donated 30 hours a week to assisting the elderly, and in addition, she regularly volunteered at a homeless shelter. I mean, unless one believes that people are morally blameworthy just because they violate the letter of the law, and I have a book arguing otherwise, one can't maintain that this citizen morally deserves punishment, because she satisfies the moral duty that justifies the law under which she'd be prosecuted. The point is that unlike perfect duties that concern themselves with specific actions, imperfect duties of the million sort can be satisfied by a virtually infinite set of actions. And consistent with the rule of law requirements of generality and publicity and predictability and knowability, legislators couldn't hope to enumerate in law all the ways in which people might alternatively satisfy their imperfect duties. And any attempt to legally privilege only a few would inevitably result in punishing people who are undeserving because they in fact fulfilled such duties in other ways. And again, consistent with rule of law requirements, judges couldn't hope to adjudicate much more general legal standards requiring simply charity or beneficence or friendship, right? So the upshot is that if people have imperfect duties, and it seems that we all do, the state has to leave people alone to choose when and how to satisfy them. And depending on how many of these duties there are, they might provide citizens with considerable arenas of choice. Okay, so I've now walked you through 7 arguments for the existence of moral gaps that might prove to be sort of promising sources of political liberty. But the liberty that they justify, however extensive its scope, is no doubt of a sort that many will find sort of uninteresting. Because after all of these arguments simply require the state to leave us at liberty when it can't find any moral fault with our conduct. All of these arguments, in short, justify legal rights to do what it's morally right to do, or at least not morally wrong to do. And that's not the promise I've made you, given the title of the talk, right? Now, arguments in support of moral gaps are just one of 4 possible kinds of arguments for why, in certain circumstances, the state simply may not be able to declare conduct moral or immoral. There remain further reasons to think that even if morality doesn't have gaps, legal institutions do. And that within these institutional gaps, people have to be left at liberty not just to do what is right, but to do what may be very wrong. So first, the state may be unable to declare conduct immoral simply because its officials are, or ought to be, in doubt about its immorality, right? In many cases, lawmakers may either lack the competence to assess accurately the consequences of certain conduct so as to declare it consequentially immoral, or they may lack the competence to determine the categorical obligations that citizens have so as to declare actions deontologically prohibited. I mean, while institutional design features like regular democratic elections and institutional checks and balances on power, they might partially overcome the motivational and cognitive and informational deficiencies of individual legislators. Many moral judgments are just likely to defy legislative competence, right? Some judgments may be sufficiently context sensitive to resist discovery by large, geographically removed groups of strangers. Others may turn on scientific facts that aren't yet established by science. And still others may require knowledge of facts that can't be obtained without adopting methods of surveillance that are either too costly or unacceptably invasive of privacy, for example. Whatever the reason, when a gap in moral competency is discovered within state actors, morality itself dictates that citizens be left at liberty from state interference, even though this may mean that citizens will get morality as wrong as legislators likely would. Okay, the second source of institutional gaps derives from persistent moral disagreement amongst citizens. Now, prominent within contemporary liberal scholarship is the view that citizens ought to be left at liberty to make their own choices whenever there is persistent disagreement amongst reasonable people concerning the morality of those choices. Now, one version of this argument just collapses back into the epistemic argument I just gave you, right? Because in the face of broad disagreement, legislators ought to be modest about what they can declare to be moral or immoral. They ought to be in doubt about the morality of siding with one group against the other group when the disagreement looks like it's a disagreement between rational, reasonable people. But an alternative interpretation of this argument makes it conceptually autonomous, because on this view, fairness, rather than uncertainty, dictates that legislators ought not to settle matters that have not already been largely resolved by public debate and discussion. So public disagreement by itself creates gaps within which the state lacks jurisdiction to act. The most famous articulation of this argument came from John Rawls in his 1993 book called Political Liberalism. I won't do justice to his argument here, but let me just log a couple of questions that, modern Rawlsians would have to answer in order to defend this claim about political liberty. So first, they have to explain how many conflicting and indeed contradictory moral opinions could be equally reasonable. Yeah? And second, they'd have to make plausible the claim, not just that reasonable people who persist in such disagreement can nevertheless agree to disagree, but also that they can work out peaceful civic relationships when they don't share and thus cannot draw upon their particular moral, political, religious, or philosophical convictions. And third, they'd have to explain how it could be reasonable for those who are loyal to contentious moral, religious, or philosophical convictions to sort of check those convictions at the door when they debate about how to structure their relationships. I mean, why would it be reasonable to abandon your most basic moral or religious convictions when they would seem to be most needed? Now, only if, modern Rawlsians can answer these questions can Rawlsians locate liberty within these so-called jurisdictional gaps born of persistent disagreement amongst reasonable people. Okay, so the third and last reason to think that liberty can be extracted from inevitable institutional gaps is this. Morality may not be gappy, but it may be highly particularistic. Its dictates may vary considerably between individuals and between different contexts of action. And the state may therefore be incapable of capturing many of its citizens' moral obligations through general laws that apply equally to all. Now, once again, one version of this argument just collapses back into the argument from moral doubt, right? If morality is highly particularistic, then legislators will likely be epistemically unable to access the demands on individual citizens. But a second interpretation extracts liberty from moral particularism without relying on moral doubt. I mean, on this interpretation, many moral obligations are so personal as to be non-generalizable, right? They're often a product. Think about the choices in your own lives. They're often a product of complex calculations that take into account each individual's talents and skills and ambitions and interests and capabilities and already made choices and existing relationships and circumstances and opportunities and agent relative reasons for action and exercises of moral powers like promising and consent. Now, inasmuch as law is not law at all, unless it conforms to the rule of law values, that is, again, unless it's general and clear and predictable and consistent and knowable by all, the law can't mirror morality if morality doesn't exhibit these formal characteristics. So if morality is highly particularistic, so that its dictates vary from one person to the next within Singapore, which has 5.5 million people, or within the US, which has 332 million people, then the state can't hope to specify in the general language of the law the actions that individuals should perform in order to lead moral lives. So in short, the particularities of morality will necessitate gaps in the law, gaps within which people have to be left at liberty to commit moral wrongs with legal impunity, right? Okay, so I have dwelt so far on the multitude of reasons to think that in certain circumstances, the law simply cannot judge the morality of citizens' conduct, either because morality itself is in some manner silent or indeterminate, or because systemic incompetencies and constraints require the law to remain silent, even when morality is not silent. Now, in part 3 of the paper, which I urged you to skip, I turned to circumstances in which lawmakers can have confidence that certain conduct is in some sense immoral. They're confident about that. The question I pose in that part is whether morality itself might require lawmakers to tolerate such immorality. Now, again, it'd be incoherent to suggest that morality might give people moral rights to do what morality flatly prohibits them from doing. But people may have deontological moral permissions to do acts that are on consequentialist grounds unjustified, and for that reason blameworthy. And it might have, deontological morality might have moral permissions to do acts that reflect vices rather than virtues and are thus archaically blameworthy. And certainly we live our lives on the assumption that we have permissions to make choices that do not maximize social welfare writ large, right? And we clearly take ourselves to have permissions to indulge our vices even when we wish our virtues would speak more loudly to us, right? We lavish our wealth on ourselves and our loved ones instead of sharing it with those who are truly needy. We waste time and talent that could be put to social advantage. We don't think ourselves obligated to donate our sort of extra body organs to save the lives of others. We feel entitled to speak our minds, even when doing so risks offending or insulting others, and so forth, right? In other words, we assume that some actions are subarrogatory. Fabulous cocktail party word, very worth internalizing for when you're on your third beer, right? Actions that are subarrogatory are actions that are in some sense blameworthy, consequentially or archaically, but they're nevertheless morally permitted, yeah? Think of how often you blame people for doing things that you think they had a right to do. You blame them for being a bad friend. You blame them for not remembering your birthday, even though you didn't have a right to have your birthday. Right? We blame people all the time for things we think they had a right to do or were permitted to do. Okay, if we can make sense of our lived assumption that people have moral permissions to do what they can be blamed for doing, then we can give moral grounds for legal rights to do what is morally blameworthy. Now, why did I have you skip over the important and seemingly vast category of moral rights to have law leave us at moral liberty to do what is morally blameworthy? Well, because the bottom line is this. If morality gives us permissions to do certain actions regardless of their consequences and regardless of whether they manifest vices, then these are not acts that can be regulated by the state consistent with my working precept that the state cannot regulate what morality does not prohibit. If acts can be blameworthy without being morally prohibited, then while the state can think them unfortunate, it cannot justifiably regulate them. So a theory of subarrogation, a theory that makes sense of how we can exercise permissions in blameworthy ways, will yield a theory of political liberty. Okay, so now let me turn to part 4 and the toughest task for a theory of political liberty, which is to advance plausible reasons why lawmakers might be morally required to allow citizens to do what morality flatly prohibits. What can be said on behalf of according people legal rights, not just to abuse their rights or misuse their permissions, but to flat out violate their moral obligation? Well, the answers that I advance in part 4 of the paper are all of a piece. They seek to demonstrate that there are moral costs to the enforcement of morality, so that all things considered, it is sometimes better to tolerate immoralities than to try to root them out. So first, you might think that negative liberty, that is freedom from interference by others, is an inherent good, so that the state can act morally only if it affords its citizens considerable freedom from state interference. Now, contrary to what James likely believes, given the paper he's going to present tomorrow, and we're going to have a lot of fun discussing, I do not find the claim that liberty is an inherent good to be particularly compelling. I mean, it simply seems implausible to me to think that not being interfered with is a good in itself. It rather seems to me to be a good because it instrumentally enables us to become our best versions of ourselves, or to accomplish things that are themselves inherently worthy, or to secure things that are themselves inherently valuable. So instead, let's think about how much liberty the state ought to accord us if liberty itself is an instrumental good. So what would it be instrumental to? Well, there are two views that hold that liberty is instrumental to autonomy, a strong one and a weak one. On the strong view, autonomy is of inherent moral worth, and it is a necessary condition of any action having moral worth. So only if an action is free, in the sense of being uncoerced by others, including the state, and intentional, in the sense of being a product of deliberation and choice, does that action have moral value. And any action that is both freely and intentionally chosen has some degree of moral value, even if in all other respects it's morally heinous. It's a rape, it's a murder. Now, on this view, people have to be left largely at liberty to make their own life choices, even at the cost of committing serious moral wrongs, because any attempt to coerce them into making morally good choices deprives those choices of moral value on this view. Okay, the more plausible, weaker view holds that autonomy adds value to actions that are themselves independently good, but it adds no value whatsoever to actions that are themselves independently bad. Joe Raz nicely articulates this asymmetrical theory. So in this view, it's possible that good but less than fully optimal choices that are autonomously chosen have greater moral value by virtue of the incremental worth of that choice than do optimal choices that are coerced. Yeah? But choices that are inherently bad are not made better at all by the autonomy with which they're made. So they can't be thought better than coerced choices to do acts that are inherently good. So on the weak view, the state might have to tolerate morally worthy choices that are less than fully optimal, but it never has to tolerate morally worthless or morally evil choices. Now, at first glance, this view seems to bode poorly for building a theory of legal rights to do robust moral wrongs. But here's the kicker. If, as a practical matter, people have to be allowed to make moral mistakes in order to learn the importance of avoiding those mistakes in the future, as we think is true when you're raising children, wait till you raise children, right? If people have to be allowed to make moral mistakes in order to make worthy choices over the long run, then people will need to be permitted to make certain autonomous immoral choices if they're ever expected to make maximally valuable autonomous choices. And while it's likely never the case that tolerating choices to commit rape or murder will yield more good choices than bad ones over the long run, it may be, for example, that tolerating so-called victimless offenses like drug use, prostitution, or smoking, or gambling, and tolerating activities that cause others just psychic harm, like offensive speech, may be necessary instrumental means of educating people to the moral perils of that sort of behavior, right? Okay, now section 4B3 on your handout makes clear that there may be other moral goods besides autonomy to which liberty is instrumentally valuable. I mean, remember that John Rawls in his 1971 book, A Theory of Justice, insisted that liberty should be thought to be a primary good because one would choose it behind a veil of ignorance no matter what else one chose. And utilitarians have argued that people have to be left largely free of coercive influences in order to have preferences that are worth summing in a utilitarian calculus at all. And very likely, people's preferences will themselves include a preference for making their own choices about how to live their lives, even when they recognize that they may ultimately make poor choices that thwart other preferences. So legislators may be bound to leave citizens at liberty to make choices that they're convinced are morally prohibited if there are reasons to think that liberty is instrumentally important for achieving things that are themselves of moral value, like autonomy or the capacity to cultivate morally relevant preferences. Okay, I've now walked you through reasons why even when citizens are morally obligated not to engage in certain sorts of conduct, the moral costs of enforcing their obligations may exceed the moral costs of citizens' noncompliance in ways that are morally relevant. We come now to the final part of the paper, the bottom line entry on your handout. Part 5 takes the question of political liberty to its final extreme. It asks whether there are instances in which citizens have no moral claims against state intervention because their conduct is flatly prohibited and the benefits of its regulation would exceed its costs, but in which the state nevertheless ought to leave citizens at liberty. Now, unsurprisingly, no version of consequentialism could permit one to argue against legal regulation in circumstances in which the consequences of regulation are better than the consequences of political liberty, all consequences considered. So you have to repair to deontological ethics, and particularly to the hypothesis that lawmakers might be subject to freestanding categorical obligations of non-interference, which require them to tolerate acts that they're fully confident citizens have no right to perform and that they could readily prevent. Now, what would make us think that this might be more than a possibility on paper? Well, deontologists might think that lawmakers are subject to freestanding categorical obligations that, as a side consequence, provide citizens with de facto legal rights to do moral wrongs. So, for example, egalitarians might maintain that lawmakers are categorically obligated to protect the value of equality. That is, to ensure that like cases are treated alike and that similarly situated people are treated similarly. And it would follow from this, for example, that those who are guilty of moral wrongs ought to be punished if, but only if, all who are equally guilty are similarly punished. Now, if the state lacks the resources or the ability to detect and equally punish all who commit a given moral wrong, say gossiping about one's neighbors in defamatory ways or saying sexist things in a bar late at night, then on this argument, the state should not punish any within the class of wrongdoers. So on this argument, political liberty should be granted whenever the state cannot act equally, if it acts at all. And just as liberty might be the byproduct of the duty to protect equality, so it might be a side consequence of legislative duties to protect other goods, like privacy or integrity, right? Okay, let me land this plane. What I've sought to do in the paper, all too hastily in this long-winded talk, is catalog all of the plausible moral means by which political liberty might be morally defended by those within the major schools of moral thought. And the job of the book that Michael and I are writing is to pick and choose from this smorgasbord of ingredients, a smaller set of ingredients that we think yields an internally consistent and morally defensible recipe for liberty from state interference. And I'll be delighted if you have additions to the list that I've taken you through. I'll be delighted by your critiques of the arguments that I've canvassed, and I'll be delighted by your critiques of my critiques of those arguments. So thank you. I'll turn it over to you.
Bravo. It's always difficult to comment on the paper which you don't find very much to disagree with. I found the survey of your various ways in which you might you find areas where ability should be guaranteed just meant eliminating. But here's my comments for what they're worth. There's no possible way that I could weigh in. There's no possible way that I could weigh in on all the various issues Professor Hurd addresses in this supremely meticulous and comprehensive paper. So in the time I've decided to take for myself in this response, I shall just address a few things in the spirit of replying to Hurd's invitation to this gathering. She writes, I look forward to the ways in which you will refresh and revitalize my thinking about this topic for the purpose of substantially revising this contribution to our book. Okay, so let me set out what I think is the dialectic structure of the paper, in case I've got that wrong, but for the sake of argument at least, Hurd accepts something like the following proposition. Where A has a moral obligation to phi, the state may, at least prima facie, require A to phi, so that in such a case, A has no rightful complaint when the state does so require A to phi, so that in this case, A would have no liberty against the state, no political liberty from the state interference where phying is morally required. Hurd never defines for us what is meant by moral. She did in this, you did more in the talk than you did in the paper, I guess. But from the text, it seems to me that it's something like this. Regarding any action A takes, it may be appraised on two grounds. Whether it is rational, perhaps more narrowly, instrumentally rational. Did A get his sums right? Did A actually fix the bicycle? Did A remember to add the paprika to the stroganoff? You know, those sorts of ways in which you could appraise action. Or secondly, did it meet any other standard of appraisal roughly concerning the rightness or value of A's action? That would be where the act is considered under the category of the moral. And as far as I can tell, part 2 is addressed to all those, whether deontologists, some sort of Kantian would be the standard example, or consequentialist, ditto for the self-styled utilitarian, who think that category 2 appraisal, moral appraisal, universally applies to all actions with some possible narrow exceptions. And so part 2 is basically all the escape routes you might get to say that there's no way you can decide that an action is morally wrong or morally right. So this is the gappy approach to political liberty. So part 2 is Hurd's meticulous examination of those who would propose to source such a political liberty from state coercion on the basis that morality is silent in certain cases of an agent's actions, that morality is gappy, to use Hurd's words. There's much that I could say about all the individual claims in this part, but I'm not going to do that here. Also, all I should say is that I'm pretty much with Hurd that these will not be satisfactory in establishing the kind of political liberty which we normally want and expect. So I'm not going to, at a short time, I'm not going to address parts 4 and 5, although I learned much from them. In brief, I would largely endorse their exploration of what are the epistemic, moral, and ethical and practical limitations of any state in regulating the behavior of its subjects, even in cases where the subject what the subject aims to do is subject to negative moral and ethical appraisal. Now, notice I have just said negative moral and ethical appraisal as if moral and ethical are two different things, and now this is my substantive response to Hurd, right? And this is where I would suggest a restructuring of the text. As those who knew Peter Burks will recall, his advice to junior scholars was that an academic paper should not read like a whodunit, where the reader must consider a range of issues to find only at the end that the writer announces the denouement, their considered view. Rather, an author should be forthright up front about what the paper seeks to establish, provide a clear signal at the beginning how it will all end. Now, with all due respect, I think Hurd falls foul of this valuable guidance. I would move her bluntly put after view of her survey, beginning on page 78 of the paper, and parts of part 3, which she asked us to skim, put those in the introduction. I'll explain why. In part 3, at her conclusion, Hurd gives what is, to my mind, the most obvious and plausible case for the right to political liberty. And throughout the paper, I was hankering for its appearance, probably because I have read her views on the subrogatory before. So the paper is called Duties Beyond the Call of Duty, and you can find the reference at page footnote 53 of the paper, which runs over pages 48 and 49. It seems to me here that Hurd's own justification for political liberty is the one most people would immediately accept, and it turns on a very clear distinction between what she calls deontic duties, and in the paper, in the presentation, she said there's 2 classes of actions which are outside of deontic duty, but are still morally appraisable. Ones are duties that fail actions that are subject to negative appraisal on erratatic grounds. They reveal vice rather than reveal virtue. And the other ones are ones where the person acts, but strict consequentialists would say that their act is inferior because it doesn't maximize value. So I'm mostly concerned about the erratatic side, as will become clear. So in this view is that the state is quite right to enforce deontic duties of right. Now, there might be cases where the state shouldn't do this for the reasons that Hurd expresses in terms of epistemic gaps and equality and so on and so forth. But in general, the starting principle is the state is right to enforce deontic duties of right, duties like the duty not to kill, steal, rape on the purely negative side, and, for example, the duty to care for one's children, for example, on the positive side. Obviously, there are some Kantians who have difficulties about any duties of right requiring that are positive, but I'm assuming that we can get around that. But the state should not, as a matter of principle, enforce duties of virtue. That is, to enforce what I would call ethical duties to pursue value rather than disvalue, duties which apply to actions which do not fall foul of any duty of right. The subrogatory encompasses those actions which do not fall foul of a duty of right, but are nonetheless the subject of negative appraisal, failing as a matter of virtue. So my thought is roughly that if this were set out at the beginning of the paper, it would help orient us to what the claims that are made that she goes over in part 2, and it highlights how desperate some of them seem to be, right? And why we would not seek to ground political liberty by expanding upon those views. So here's, I'm going to end this with a Formula One reference. So I think if she did this, put this stuff at the beginning, I think that Hurd, after a long slog of a race, Hurd would take the checkered flag, as well as a very well-earned victory lap. But graciousness requires her to acknowledge that she began in the pole position.
I love it.
Okay, so do you want to respond to any of that?
I can, or we can open it up, or?
Sure, say a few words.
Okay, just the fewest. I'm incredibly flattered that you found in part 3 something you thought was so core to my thinking and so significant as a locus of political liberty that you thought it should take center stage. You can tell that it wasn't part of my motivation to pull that rabbit from the hat by the fact that I asked you guys to skip that part and didn't mention it in my talk. So you can tell that I didn't think of it as a rabbit to be pulled from a hat. Namely, you have to recognize that a lot of this material is 20 years old. And 20 years ago, I didn't know anything. Or at least I knew a lot less then. And I make some Hofeldian mistakes that Andrew's got to impale me on because I went back and read. I went, oh man, I sure didn't understand Hofeld back then. But But it was at the time that I wrote this, it was a genuine inquiry into all the little pockets and holes and crevices and cracks in which I might be able to mine morality for, liberty. And along the way, of course, I do reveal that I think some of them are awfully little cracks and crevices and not worth sticking your finger in. And others turn out to be, I think, really, really interesting and large and promising. So my motivation wasn't to sort of arrive at a theory of political liberty premised on the distinction between the deontic and the eretaic. And to have that be the lead thesis that emerged from the paper. Now, it is very, very true, though. You are absolutely right that that distinction is going to play a big role in the book. Because we go on to, what is it, Michael, 4 chapters that take up a number of the ingredients from this article. And that is a very substantial ingredient that emerges as something that informs multiple chapters. And in fact, the article that you refer to is actually going to be effectively a chapter in the book. So you're not wrong to see that buried in part 3 that you didn't read is a very big piece of machinery that's going to do a lot of work in the book. That's just to give you your point, for sure.